Today's topic is our first and might be one of the most important of all this conference is medical marijuana and the workplace. As you all know, the topic is incredibly relevant at this time in our state. The speakers at the head table will provide necessary information to effectively manage medical marijuana in the municipal workplace. It's coming, it's here, we've got to deal with it. Our first speaker is going to be Wayne Young. Wayne is a partner with Friday, Eldridge & Clark. He specializes in labor and employment law. Next is our own Municipal League Counsel, Code and Legal, has researched the Fourth Amendment as it pertains to this topic and will provide insightful information. And last, certainly not least, the test guru of all is Jeff Sims, president of A-Test Consultants, who has worked with League for many years, and he will present information on testing related to this topic. So right now I'd like to first introduce Attorney Wayne Young. Wayne.
Thank you, Mayor. A lot of you guys out, and ladies and gentlemen out there are politicians, and so I studied political science at Arkansas Tech in Russellville. On that first Wednesday morning in November of 2016, when I woke up, there were a lot of things that surprised me. Several outcomes that surprised me, none of which probably surprised me more than the outcome on the voting on the constitutional amendment for medical marijuana. It passed by what I consider to be a relatively narrow margin in the 52 to 54% range, somewhere in that ballpark. But it passed, and so now it's here. And the first thing I would say about it is that's important to know is that it's not in the code. Anything I will be talking about today and doing the CLE for the attorneys tomorrow, this, by virtue of the initiated voter process, is now an amendment to the Arkansas Constitution. So if you or your counsel are going to go look for, well, where's the medical marijuana law, it's not in the code. It's Amendment 98 to the Arkansas Constitution. So that makes it distinct and somewhat, more authoritative than a mere code provision. On the hierarchy of laws, obviously our Constitution is a notch above the code. So what did it do? I've heard a lot of misinformation bandied about, well, what's the law require? How easy is it to get a marijuana card? Does it allow you, can you be high at work? Now, are you protected if you're high at work? All that sort of things. Most of the things I've heard are don't have a lot of truth to them. So we'll try to pull the curtain back today, talk about some of the myths I've heard, and demystify the law a little bit and help everybody understand exactly what the law does. The law provides a mechanism for what the amendment calls qualifying patients to get a registry identification card. And the registry identification card is the term of art in the amendment. The Department of Health has started issuing them. They look a lot like a driver's license. And they are good for 1 year unless the doctor certifies a shorter term. They cost $50. It costs $50 to get the card from the Department of Health to get it issued. The other requirement is that you have a written certification from your physician or healthcare provider. And the written certification, the most important thing I could say about that is it is not a prescription. It is not a prescription for medical marijuana. So when you have an employee or you have a friend, someone tell you, I have a prescription for medical marijuana in Arkansas, that's incorrect. That is in the actual amendment that the written certification is not a prescription. So what is it? It's basically the doctor or the physician, the care provider, certifies that the patient has one of the conditions that qualify for medical marijuana use. Crohn's, cancer, glaucoma, irritable bowel, fibromyalgia. It runs the gamut of various conditions, and those conditions are listed in the amendment. So the doctor certifies that their patient has the condition. The patient then takes that certification with their $50. They go to the Department of Health and they get a card. And that allows them to purchase and possess 2 ounces of marijuana. I'm not going to get into all there's been some news on criminal prosecutions on if the patient has to have the packaging from the dispensary with their 2 ounces at a time. And again, that's beyond, I'm not a criminal defense lawyer or a prosecutor, so I have no expertise on that. But I will say that, you know, it is limited to 2 ounces of possession and purchase at any one time. To give you an idea of the scope, I checked the Department of Health's website today, and as of June 7th, they are saying that there are 13,616 cards in circulation. That number sounds low to me. I frankly anticipated when this passed that there would be far more individuals with a card than that. I think the slow response has been because of the slow process in licensing the cultivators and the dispensaries. And that's important. A couple other important key definitions to know. A lot of litigation, a lot of news on the licensing process for these 2 types of entities, the first of which is a cultivator. If you live in one of these areas of the state where there's a cultivation facility, you probably know. They're the folks that are the 8 licensed entities in the state that can grow the drug. And the dispensaries are the ones that are responsible for the retail sale. Anybody here from Hot Springs? You guys have the couple of the first dispensaries in the state open down there. So the dispensaries buy the drug from the cultivator and then sell it retail to the patients. I've heard it's very expensive. I don't know exactly what, relative to the black market sales, what the cost is, but I've heard that it is very expensive to buy in the dispensaries because the dispensaries effectively have somewhat of a monopoly on the sale at this time. There are 32 dispensaries scheduled to open at various geographic regions throughout the state. If you have one opening in your city, you probably already are aware of that. So the patient gets their card, they buy the drug, and then what? What if this person is your employee? What if this qualifying patient is a city employee? What are the rights and responsibilities of the respective parties at that point in time? Well, the amendment also contains a few employment protections. And the amendment, as passed by the voters, stated that employers could not discriminate against individuals based on their status as a cardholder, number one. So if someone just identifies themselves as a cardholder, you can't take adverse employment action against them just because of their status as a cardholder. There's one exception to that we'll talk about before I'm finished. The other is that employers, on the other hand, on the other side of the coin, employers were not required to accommodate an employee being under the influence of the drug. So this is the answer to the question, can you be high at work? No, the amendment does not allow anybody to be impaired or high at work any more than they can be drunk or under the influence of prescription medication at work. So you can't be under the influence of the drug. And as Jeff is going to say, the science and the technology of determining whether someone is under the influence of marijuana is difficult at this point based on the urinalysis technology that most of us use. So Jeff will talk more about that. But the amendment talks, you don't have to accommodate someone being under the influence, number one. And number two, you don't have to tolerate or accommodate any ingestion of the drug at work. Another question I get all the time, are they allowed to smoke at work? No, it's not like you don't have any duty or to accommodate the ingestion of the drug at the workplace, whether it's smoking, edibles, oils, whatever the case may be. So that's basically all the voter-initiated amendment said. And so the business community together with, we got together with some employment attorneys from other firms in the state and started, well, the term under the influence is not defined. And so how are we going to give employers guidance on knowing whether an employee is, whether they can feel safe in taking action against an employee when the urinalysis can't adequately tell us at this point whether the employee is under the influence. Number two, there was a concern about, and this is particularly relevant to this crowd, what about employees that are in safety-sensitive positions? What about police officers that carry a gun? What about EMS workers that perform or are charged with, being alert and on call and performing life-threatening procedures? 911 responders, 911 dispatchers, 911 dispatchers. What about, firemen, all down the line? There are a lot of city employees that perform what I would consider to be safety-sensitive positions. The amendment as voted on didn't include anything that made them any different than any other employee. All employees were treated the same. So the legislature in 2017 passed Act 593, which the amendment itself gave the legislature the authority to pass an amendment without going back to the voters to supplement Amendment 98, which the legislature did in 2017. And so that amendment, the act of the legislature kind of put a lot of meat on the bones. And the last things I'll say before I turn it over to back to the rest of the panel, it defined what under the influence meant. And it sort of took into account the fact that we don't necessarily can't tell from a urinalysis drug test whether the employee is under the influence. So it basically set up a definition where if the employer has a good faith belief that the employee is impaired by the drug, together, and then that can serve as a sort of a safe harbor or a protection for the employee as long as that determination is made in good faith. So some of the type of examples of criteria that are given are things like odor, slurred speech, irregular activity, and there's a list of those things that are contained in the amendment that I would encourage you to go and look at and train your staff on. And Jeff Play will talk about that too. I think a key on this is going to be training staff to recognize the symptoms of impairment, so that will in turn alert the staff to know this person needs to go take a drug test. And if you have that witness that can say, that manager that can say, this person exhibited symptoms A, B, and C, their eyes were bloodshot, they smelled like marijuana, they had slurred speech, and then they failed the urinalysis for THC metabolite, then the amendment protects you in taking adverse action against that employee because they were under the influence based on how that term is defined. What about safety sensitive positions? The Act 593 came in and created a category of safety sensitive positions such that it gives the employer more discretion and leeway on being proactive with those positions to make sure that the employees in those positions aren't engaged in any current use of the drug. So, for example, a police officer would certainly qualify as a safety sensitive position because, as it's one of the criteria for a safety sensitive position in the amendment, is that the position carries a firearm. So if you're interviewing for a police officer position, you extend an offer to the applicant. Say he takes he goes through a urinalysis test, drug test with Jeff's company. Jeff reports back, his MRO reports back, well, he's hot for THC. Okay, he's positive for THC metabolite. Okay, and then you notify the officer, sir, sorry, we're going to have to withdraw that offer because you were positive for marijuana. Officer says, well, hold on, here's my marijuana card. Okay, in that scenario, that marijuana card does not protect that applicant. That's a safety sensitive position, and if they fail a test for a safety sensitive position, that equates to current use and you can disqualify them from that position. So that's really important then, right? Safety sensitive positions are really key. So you need to get with your counsel, get with your HR, and identify now. Identify now. The law says you have to identify those positions in writing. So do that. Just because the person qualifies, just because your police officer carries a firearm, of course, and qualifies as safety sensitive under the definition, that might not help you if you haven't designated that position ahead of time in writing. So that'll be my message to the lawyers tomorrow as well. A big tip there. Be prepared for this, update your policy, and critically, you guys are going to have so many of them, know your safety sensitive positions and designate them in writing and understand the protections the law gives you on account of, with respect to those positions. So I probably went over my time, Mayor, but I appreciate the indulgence there.
Thank you, Wayne. I've just wrote down about 3 or 4 different questions, and I'm sure we'll have time to get to those in just a minute. Next, we're going to have one of our lawyers at the Municipal League. I want you to pay attention to Lanny, and then in the next session, it's starting at 4:30, some other of our lawyers are there. just to see how smart these guys are that lead up our legal team. So we're really proud of the lawyers that we've got on staff, and Lanny's one of them. Lanny?
I'll take any compliment I can get from Mayor Smith. There was one state representative who one day, looked at me and he goes, "Hey guys, he may look like a child, but he's smart as a whip." I'm like, well, we could have just used the latter half of that. You didn't have to say all of it. So I'll take that. So I'm going to echo a lot of what you just heard from Wayne, and especially where you heard about safety sensitive, security sensitive. These sorts of things are doubly important, maybe even triply important, and I hope you know I'm not one to exaggerate. I'm going to give you 3 reasons, including what Wayne said, to know these terms and to be familiar with them and know what to do with them. So the big thing that everyone, I'm sure, is thinking about is, well, okay, we've got this medical marijuana. What about drug tests? I see Jeff from A-Test is up there. What we really want to know is, who can we drug test? How can we do that? What happens if we see someone test positive for marijuana? And I'm going to back us up. So the most important thing to think about in all of this is the Fourth Amendment to the U.S. Constitution, which we all think, we're imagining people screaming it while we're watching Cops or Law and Order. Well, it also impacts us because we're public employers. And the Supreme Court has said that drug tests are a search under the Fourth Amendment. And if you think about it critically, I can't imagine there's few things as intrusive as a drug test. If someone stops me on the side of the road, that's inconvenient. Someone sends me for a drug test, okay, that's a whole nother level. So clearly this is something that's under the Fourth Amendment. And I hope we have some Fourth Amendment scholars out there, because the Fourth Amendment, doesn't just say we can't ever do this. What the Fourth Amendment says is we can't have unreasonable searches. So we know this is a search. We know we can't have unreasonable ones. But when can we do this? The question is, when is this reasonable? And there's a couple of times when a drug test is reasonable. First, when we have reasonable suspicion, which Wayne mentioned some of the specific guidelines kind of given in our new medical marijuana amendment. It kind of tells us, hey, here's some examples. Or a search is reasonable when we have someone who's in a security-sensitive position, where we go, well, hey, because you've taken this very important job, this job where the public really relies on you to be able to work at a moment's notice with the utmost attention, you can be drug tested. That's reasonable under the Fourth Amendment. And then there's another one where it's security-sensitive, and that one's a bit tougher to pin down. But to say there's a certain point where you're working with such confidential, such important information where we go, yep, we can drug test you. That is something that is very reasonable. And I'll back up again and go back to reasonable suspicion. So the one of the 3. What that comes down to is just like what our police officers have been dealing with for years. We're looking on specific facts or reasonable, which is always the answer on Fourth Amendment questions, specific facts or reasonable inferences from those facts that our employee is under the influence of a controlled substance or has used a controlled substance in the last 24 hours. And what that does when we have those specific facts, so something more than guesswork, something more than, well, I heard his cousin deals drugs. Well, that's not very objective. That's speculative. We want something more than that. Once we have that, a drug test becomes reasonable. We could send them for one. And now then let me bring it back to the Medical Marijuana Act. So let's say it seems that, we've ticked off the boxes. We go, well, we think this is a reasonable search. Laney's been acting funny today at work. He's been exhibiting these signs, which we all know because we pay great attention at the Municipal League Convention. I'm going to send him for a drug test. And you do that and it comes back positive for marijuana. The question then will be, well, does Lanny have a medical marijuana card and is he protected under the amendment? And what the amendment tells us is that just because someone has a bad test, if they have a card, you can't fire them just for that test. But now that, as you heard, we don't have to accommodate people using it at work and we don't have to allow them to be under the influence at work. But a drug test is part of it. So we know we're not going to fire someone if they have that card which says you can legally do this in Arkansas. We're not going to fire them just because they tested positive, because of course they're going to test positive because they have medical marijuana. And that's kind of the broad strokes of reasonable suspicion. Now then, the security sensitive, it's exactly as Wayne said. We're looking at police officers. We're looking at people who a momentary lapse in attention could lead to significant harm to the public. Your fire officers, your police officers, lifeguards, those sorts of jobs where we think one mistake is going to lead to something catastrophic happening. And on those people, we could do a drug test if we wanted pre-hire, or we can put them in a random drug test and say, hey, whenever this computer spits out your number, you're going to go for a drug test because we need to be absolutely certain that you're not going to have any problems. So there's not going to be a problem when you're aiming your gun, when you're trying to carry someone out of a burning building. And if they go, well, what about the Fourth Amendment? We go, well, the Fourth Amendment says this is very reasonable. We get to do it because we care about the public. And it's tough for me to mention the security sensitive, so the third little one, because the Supreme Court has said almost nothing about it. What I can tell you is a security sensitive position is someone working on a nuclear reactor or at the National Treasury. And short of that, I can't give you a whole lot of information. Employees at a police department, they really fall under the police subset of we can drug test them because they deal with this confidential information, have access to narcotic investigations and so on. And aside from that, I'm not really sure when this one applies. So we'll use that one sparingly when you come to me for advice. And I wanted to add one more thing before I turn it over to Jeff. There's been some questions about, well, we don't want to fire anyone mistakenly. So can we ask everyone to tell us that they have a medical marijuana card? Can we just put in our policy, tell us you have a medical marijuana card? And I say don't do that. Now that is medical marijuana and is illegal under, federal law, always throws a kink into everything. But what we're essentially asking, if we're thinking about asking our employees, hey, do you have a medical marijuana card? What we're asking them is, hey, do you have a qualifying disability under the medical marijuana amendment? Which I would never want us asking our employees, because of course we wouldn't, because of the Americans with Disability Act. We want to make as few medical inquiries as possible. Now, I'm not saying that's the end of the story. The ADA, which is, I'm thinking, let's analogize this to a prescription. When can we do things with prescriptions? And the EEOC's guidance on this issue is, no, you shouldn't ask every employee to tell you about every piece of medicine they take. That's not good, that's invasive. You don't need that information. But if it's in a position similar to a safety sensitive position like I just talked about, the standard is a bit different since we're talking about the ADA. And this is where an employee being under the influence, if they would pose a direct threat to themselves or others, then we can probably ask that they report medication that might impact them. And I think we'd be pretty safe saying medical marijuana would fall into that category, which is to say if we didn't exclude them from those positions, which we have the ability to do, to say, hey, you can't do these things under the Medical Marijuana Act, but if we wanted to ask everyone and say, hey, we're going to treat you just like everyone else, but we're going to need to know this information because you're in this very important job, and that's probably okay. So I'll stop it there and turn it over to the next one.
I just thought about something. Those of you that your employees are covered under civil service protection, one of the first things we probably all need to do is we need to train our civil service commissioners because they might have to deal with some of this, probably will end up having to deal with it, so they need to know what the laws are too. So that's something just popped in my mind. So, A-Test consultant Jeff Sims. Jeff.
Thank you, Mayor. Thank you, Lanny. Thank you, Wayne. Thank you for having me here again. I think this is my 13th or 14th visit to the Municipal League's annual meetings, and I'm grateful for the Municipal League and the many things that they accomplish and service you with. A couple of things I kind of want to go through. A-Test does a lot of work outside of Arkansas, so we've been really exposed to the medical marijuana initiatives all the way since '96, and we've represented some very large accounts all the way from Ralph's grocery stores on the West Coast and a lot of different environments, the Pacific Northwest National Laboratory up in Washington State. So we've seen it from the government side of it, we've seen it from the private employer side, and how those employers actually dealt with it. So I kind of want to do kind of Lanny's approach and kind of walk back a second and kind of tell you about the medical marijuana industry in itself. And bear with me, I mentioned how many years I've been here. I get to put on cheaters now, which so many of us get to carry in our pockets now. I kind of want to walk through. There's Legalized states, we have 30 medical marijuana states. We have 9 of those that are recreational and 16 that are CBD only. Only 4 states now with nothing on the books for medical marijuana and dealing with it. So it's here to stay, okay? That's kind of why I was pitching that out there. Medical marijuana sales in 2018 estimated at $4.5 billion. Projected medical recreational marijuana consumer market in the year 2024, the projection is to be $37.3 billion that year. Number of cannabis businesses in the United States as of 2017 is estimated at 28,000 businesses that sell cannabis products. Average price per ounce of high-quality marijuana in the United States as of November 2018 is $320 an ounce. The least expensive city, if you're interested in traveling, the least expensive city to purchase marijuana is Aurora, Colorado, and the most expensive state is Michigan. Number of marijuana patients per 1,000 state residents in California as of May 2018 is 23 people per 1,000 in their state. Number of caregivers, get this, number of caregivers registered with medical marijuana cards in Michigan is over 33,000 people. This isn't the patients, these are the caregivers to deal with grandma. Colorado numbers, total number of marijuana patients as of December 2016 in Colorado is 342,000, almost 343,000 patients. And total recreational and medical marijuana sales in 2016, this is in Colorado alone, was 1.51 billion in sales with an annual tax revenue in 2017 of 21.21 million. I say all that to say this isn't about compassion, this is an industry, period. And it's all about money, all right? So be prepared. Obviously, Arkansas is going to see another wave of other initiatives that will be coming our way. Who are the average medical marijuana patient that gets a card? It's a white guy. Average age is 42. Okay. The typical condition is just chronic pain. Okay. The cancer patients only represent 1.4% of the cardholders, and people with chronic seizures, that's 1.5% of the users. Wayne just mentioned how many cardholders we have now in Arkansas. It's like 13,000 and change or something right now as of June 7th. So obviously, we're just now kicking this thing off, so there's no telling where this projection is going to actually end up. But, obviously this gets us in the weeds. Now, when this industry came in and decided to go ahead and, help push the legalization in Arkansas, they were really caring about employers, right? And our needs and our issues that we're having to deal with. So I'm kind of going to piggyback on what Wayne and Lanny were talking about and kind of go in some areas that people were, that benefited from some of the lobbying in 2017. 593, that was a perfect to write in. We went in and we put some protections for the safety sensitive positions. We need to live in that world and think about the safety sensitive positions. This is exactly back in, who in here is a municipality has people with CDLs, commercial driver's license, or gas pipeline? A lot of you guys, okay? So remember, the US DOT testing program was mimicking current and safety sensitive positions in the late 80s when they were rolling this out. And they had a model through HHS of those safety or security sensitive positions. Obviously a pilot is a safety sensitive position, correct? A truck driver is a safety sensitive position. A gas pipeline worker is a safety sensitive position. So, so we need to live in that world of safety sensitive positions and think about that. And if you haven't taken the initiative to look at those job descriptions, we really, really need to roll up our sleeves and start catching up on that, okay? I mentioned DOT. You have to understand, US DOT if you're mandated under DOT, those safety sensitive positions will trump every other position in here. The DOT has put out policy statements multiple times on this, and they basically said if your employee is federally mandated under our program, there is always barber college. You can change occupations. That's pretty much what they said. Okay, they didn't quote say the barber college, but they just basically said you can change occupations. So remember that under the DOT testing program, very specific under a lot of the federal agency security programs. I work with the Pacific Northwest National Lab, which is the Department of Energy. They even have what's safety sensitive or non-safety sensitive in the world of random testing. So random testing obviously is a different animal. You got your Fourth Amendment protections obviously with the federal agencies, just like you would obviously with the civil agencies. Speaking of DOT, just to kind of give you an idea, DOT's obviously been looking at this and obviously concerned about this and looking at the projections of where they're going to be in the next couple of years. Last year, to give you an idea of how many marijuana positives they had through DOT, they had over 44,000 positive marijuanas through the US DOT testing program. And this is a DOT testing program that kind of has evolved and morphed into other things from 1989. But when we started DOT testing, there was a reason, right? You're looking at justification a lot of times in a lot of these programs. What happened to cause us to now bring this thing together? We had 11% positive rate of this industry, and we had several accidents. We had an Exxon Valdez case. Remember that, the Exxon Valdez case, alcohol related? Okay, so we had a lot of things that started this US DOT testing program. It's the same thing that we're dealing with now. We're now, though, crazy as it may seem, even though we started at 11% and we have a 44,000 positives for marijuana last year, DOT's now under 2% positives, okay? Well, what changed between 11% and 2%? And a very aggressive deterrent program called random testing. So it really went into play, and it selectively pushed out those positions or those employees that were in those safety sensitive positions that shouldn't be in those positions. So we've got that. So let's keep on walking forward. One thing that Wayne was hitting on are certain card holders and certain acceptance of the patient and the caregiver and the availability for them to purchase their 2.5 ounces every 14 days. One thing that they also authorize is out-of-state patients. So if they have a valid card from another state, they're allowed also to use that in our dispensaries here. Which brings in the impairment issue. Impairment is a serious issue and a very big concern because it was listed in the ballot initiative originally, and then we've had to clean some of this up in the amendments. So, first of all, we need to do more signs and symptoms training, reasonable cause signs and symptoms training. Who in here has actually had us out to y'all's place for reasonable cause signs and symptoms training? A lot of you guys have had that. There's a lot of resources out there. The highway department will help us with that. And Laney and several of us have been talking, and we're going to provide that for you at no cost if you're a legal defense member. We're going to do that quarterly at the League building. So that's a new product that we're going to start putting out there for those supervisors that we didn't do a face-to-face with when we were out in the field. We can bring them back in. So that's a new thing. And the next thing we're looking at is that Health and Human Services is approved, and HHS, to kind of give you an idea on the stacking order of things, under the Omnibus Transportation Employee Testing Act in 1991 that mandated drug testing of transportation workers. They basically said in that law, DOT and other agencies, you got to rely on the judgment of HHS in how you test and why you test and the reasons. So HHS has approved oral fluid drug testing, okay, and that's a good thing, and I'll tell you why. Now that we look at this world where in a urine drug test, you may have collected a urine specimen on somebody and they could have consumed the drug 7 and 10 days ago on marijuana. Now we've got this gap in here. Were they really impaired taking action on just a drug test? They weren't on urine. Oral fluid testing is going to brings that gap down to less than 24 hours and allows us to test for a metabolized version of the drug and the parent drug inside, inside your upper respiratory tract. That's a good thing. So now we're narrowing this drug testing technology that we've never really had before. So we're making some strides on that side of it to help our law enforcement community and also some employers make sensible judgment calls, other than the reasonable cause or the signs and symptoms identification, also using the science behind it as your evidence. Medical review officer, Wayne talked about it, the MRO reporting back a result back to you as a final, here it is, take action on this individual. An MRO, or a medical review officer, is a person that's trained to specifically validate and look at positive drug tests, invalid test results, alternative reasons of why if somebody may have failed a test. In the MRO process, we've started under the DOT program this last year, looking at more fitness for duty type elements when we're interviewing that donor, because we're a gatekeeper. We're calling them and asking them, is there some type of medical reason to determine why you have a positive test result? Well, the gatekeeper is a medical professional talking with another medical professional at this point, getting you out of the loop of that, okay? So the MRO at that point can report back a result back to an employer that says we have a safety concern, or it's a negative with a safety concern, or we contact that person's physician to determine if we can change them to an alternative drug. So there's a lot of things going on behind the scenes on the analytical side of it, a lot of it on the policy side of it that we're working through. We're seeing a lot of phone calls pop up. Anybody heard of CBD prior to us talking about it? CBD. Could have it all. You go to Missouri, that's all you see at every gas station. It seems like, hey, sell CBD here. It's really a big, yes, cannabidiol, this is an item that makes up 40% of the cannabis plant. CBD is what medical professionals are looking at as a potential benefit inside the plant itself. Okay, so several states, a lot of states outside of Arkansas, approved just CBD only, okay, where you got that product, you didn't get the whole plant itself. So CBD is on the rise, which begs the question, can you fail your drug test since it came out of the cannabis plant, right? Again, this is 1,000 phone calls. I'm here to tell you, if it's done properly, no. You won't fail your drug test. We have a lot of established cutoff levels. We give you a certain amount of a bar before we even call you a positive. So CBD, you wouldn't do that unless you're trying to do your own extraction at home, and there's no telling what you'll come up with at that point. So anyway, or consumption and extraction, back and forth. So, okay. So, in the future, basically put a hit list of things that we're going to probably see in the near future. Number one, we'll probably see a huge push for recreational marijuana. I think there's already looked at some language already. I think through the AG's office, I think they'll already look at the recreational marijuana on the next ballot initiative that we have. So I'll see that on the horizon coming up. Another thing is this: as we start dealing with physicians that have made recommendation for the use of, and I'm using the word recommendation because it's not a prescription, the recommendation to use medical marijuana. A lot of physicians in other states where we didn't have employer provisions put in there and protections for employees, we started seeing physicians, any vendors in here? Not just municipalities, but any vendors? Okay, never mind. But anyway, we do, like I said, a lot of activity outside of Arkansas where they don't list in their bills the employment protection. So what would happen is a physician would write a recommendation for marijuana, but also write a prescription for Marinol or Dronabinol that actually has THC in it, and it's in a pill form. So those patients would go get a prescription for it. So then we had to try to determine, was this a weed version of the plant, or was this a pill form of the plant with THC in it? So in dealing with that, we've had to actually go and do more exhaustive testing, and we have a product that we test for THCV to determine if it's vegetable or in a pill form. So that's a new trend that I could see in the near future. We see recommendations and the problem solving and the vetting out of the recommendations that will be in the near future. So now, and the last thing is, it's just kind of looking at my crystal ball here. Our future is going to be also a huge increase in the black market trade of marijuana in our state. It happens everywhere. It happened, it happened in California. It happened in, Nevada. It happened where you'll see a large importation, because why would you want to pay $300 an ounce at a dispensary when I can go down the street to Bubba and pay $180? Okay, so there's a huge difference there, and so that's all obviously a common concern that we've had from the law enforcement community. So with that, I'm closing it up, and if you guys have any questions, we'd be more than happy to answer them to the best of our ability, and I'll be sticking around afterwards as well. So,
Thank you, Jeff.
thank you.